All right, everybody, this is Brett Thompson, Thompson Law Group World Headquarters. It's Tuesday, so I think you know the deal. We're going to do a Teaching Tuesday, also known as a Closing Ninja Classroom. I have received questions about easements. So we're going to do a summary of easements. We're not going to do a deep dive, but I'm going to go into the concept of easements and give you a couple of different examples. So this is my beautiful artwork here. This is a lot. There's a house right here. This is the public access. This is the public street right here. Very often when developers will create a neighborhood, they will put a subdivision plat to record. And either on the subdivision plat or later, they will grant easements to the city or different utility companies. And a very common easement, you'll see a dotted line that goes along the boundary of your lot, okay, like this. So this would be an example of a drainage easement, okay? So this could either be a ditch or you could have underground piping for the stormwater drainage. And the developer would put an easement agreement to record, formally granting an easement, for example, to the city. And it says that the city can access along this area here the property to maintain and repair their easement. So they can clean out the ditch, or if it was an underground pipe that got crushed or destroyed, they could come in, take the pipe out, put a new pipe in. So an easement is always going to be granting an access to the property or a use of the property, but it's never going to be granting ownership interest in the property. So this owner owns the property all the way out to the line here, okay? So the boundary line is here, but inside the boundary line, this dotted line indicates where the easement lies, all right? Another example of an easement would be utility easements, water, electric, your cable companies, VEPCO. You would, the developers or landowners could grant easements to the various utilities companies, allowing them to maintain their lines, replace their lines, repair their lines. They again could access the property wherever the easement lies, and within that easement area they could work and repair and maintain their utility easements. Another example of an easement would what we call ingress and egress. So that's the right to go over the lands of another landowner. So we'll do another example here. So this time we're going to do two lots. So this property was subdivided at one time and there were two lots. Okay, so we're going to call this lot number A and lot number B. There's a house right here, and let's say there's a house right here. Okay, so this is a public right-of-way, so it's easy for lot number B, the person that owns this house, to access this property. However, we need an easement, for example, could be right here. So this would be an example of an ingress and egress easement, whereby the owner of lot A could drive his car up the easement and access his property. So he could go back and forth over the easement. If we're going to get technical, lot A would be the dominant landowner and lot B would be the servient landowner, because lot B, this lot serves lot A, meaning that the owner of this property can go over the lands owned by lot B to access this property here. So that's the example of an ingress and egress. So you can have pedestrian ingress and egress. You can have vehicular ingress and egress. So the easement agreement would set forth how it can be used. It may say you can't park cars on there, but you can drive cars over it. So the particulars of what's granted would be in the actual easement agreement. If we want to get more technical, let's say that this property was subdivided, but no one ever recorded an easement. So there's no recorded easement of record. So right now, this is what we call landlocked. The owner of lot A cannot access. There's no access points to get to his lot. So if the owner of lot B was a knucklehead and he did not agree to grant an easement to the owner of lot A, the owner of lot A could sue lot B, the owner of lot B, and he could say that he has, under law, he has an easement by necessity. So an easement by necessity is a doctrine of law saying that once this property was subdivided into Lot A and Lot B, it's implied under the law that it's necessary for the owner of Lot A to have an easement or some access to the property. So the owner of Lot A could sue the owner of Lot B, and the court could grant an easement by necessity, and the order could say that, hey, we've got to put an easement right along here so the owner of Lot A can access his property. Now, let's say that we're out in the country or something. Maybe, we're in a rural area and we've got the same situation, but, could be two farmers, okay, out in the rural area. And there was never any formal easement put to record. There's nothing recorded. But over the last 20 years at least, the owner, Farmer A, okay, has been using this lane right here. And it could be a gravel road. You could see the tire ruts or whatever. But this guy has been accessing and going over the property of owner of Lot B for at least 20 years, all right? And he's been treating it as his access point. If he has done that, he could then petition the court. If this guy's a knucklehead and he don't want to grant him an easement, the owner of Lot A could petition the court and say that he has an easement by prescription, or also called a prescriptive easement. And so there are legal requirements to prove a prescriptive easement. One is that you have to prove that over a period, uninterrupted for at least 20 years, you have used this access as if it was your own, out in the open, exclusive to yourself. So there's different elements that you would have to prove that you've done over 20 years in order to satisfy the legal requirements. And if you can put on that evidence in court and you can satisfy the legal requirements, the court would be inclined to grant you an easement by prescription, or a prescriptive easement, and enter an order saying, hey, because lot owner of A has been using this under the law for at least 20 years as his own easement, we are hereby granting the easement. So he would put to record an easement. So in a nutshell, an easement is the right to access or use property, but it's not ownership interest. So easements by necessity, prescriptive easements, we've got utility easements, we've got ingress and egress access easements. In a nutshell, guys, that is a summary of how it works. I hope you enjoyed this Teaching Tuesday. Thank you.